In Coeur Alaska Incorporated versus Southeast Alaska Conservation Council, we'll see whether the Army Corps of Engineers or the Environmental Protection Agency has the authority to issue a permit to discharge fill material into a navigable water. In 2005, Coeur planned to reopen a gold mine in Alaska. Although the mine had been closed since the 1920s, Coeur believed the mine could be revived using a froth flotation method. Froth flotation involves churning crushed rocks in a chemical solution that forces gold-bearing minerals to float. The mixture of water and crushed rocks left over after the gold is removed is known as slurry. Coeur wanted to dispose of the slurry in Lower Slate Lake, a navigable water. Based on how much slurry Coeur would discharge, the lakebed would eventually rise above the surface of the lake. Coeur applied to the Corps for a permit to discharge the slurry, and the Corps approved the permit. Southeast Alaska Conservation Council, or SEAC, sued the Corps. SEAC argued that the Corps didn't have the authority to grant Coeur's permit. Instead, SEAC argued that Coeur should have applied to the Environmental Protection Agency, or EPA, for a discharge permit. However, SEAC claimed that neither the EPA nor the Corps should permit the discharge because it's unlawful and violates the EPA's performance standards. Coeur and the state of Alaska intervened as defendants. The district court granted summary judgment in favor of Coeur and the Corps. SEAC appealed. The Court of Appeals reversed. The court held that Coeur needed a permit from the EPA under Section 402, and that the discharge would violate the EPA's performance standards. The Supreme Court granted cert.